Thank you, everyone who was hoping to participate in today's webinar on Legal and Tax Guide to Staying Compliant in 2025. Um, yes, yep, that is the intro. Yep. Thank you, everyone, apologies, everyone who didn't get the link today for the webinar on Legal and Tax Guide for Staying Compliant in 2025. Unfortunately, we did have some technical issues, but we are going to proceed with the webinar with our two guests. And if there are any questions, then please forward it to me via email afterwards when I send a bulk email out, including these slides. And I'll make sure I can get it to Damon and Tim, and hopefully we can get those responses out to everyone. So, whether you're just starting out or running a growing business or scaling up, staying on top of your legal and tax obligations is crucial. And today we are breaking down everything you need to know to confidently navigate compliance in 2025. We are thrilled to be joined by two incredibly knowledgeable experts in their fields who will guide you through today's legal and tax essentials for running your business. First up, we have Tim Quinn. Tim is a qualified chartered accountant with 17 years of experience across the full business life cycle, from startup to exit. He's worked closely with entrepreneurs and business owners to help them stay compliant, minimize tax, and make the system work for them. But not the other way around. Tim's led tax divisions at the director level and knows exactly where business owners tend to get stuck, and he also knows how to fix those sticky situations. Today, he'll walk us through key changes for FY 2025, common compliance traps, and how you can stay ahead with smart planning. And later we have Damon. So many of you will know Damon already from our legal advice plan. He's one of our top rated lawyers with over 300 five-star reviews on our Meet the Lawyers page. Damon has decades of experience in commercial and startup law and has represented clients in high-profile intellectual property cases, among a lot others. Today, he's here to talk about how to protect your ideas, your brands, your IP, among a plethora of other things. Something every business owner needs to get their head around. Essentially, we'll be able to cover it for you guys here. And obviously, if there is any extra questions or something we didn't cover, if it's not necessarily related to what you want to discuss, please send them to me via email and we can go through that in the Q&A. Yes, perfect. So, before we dive in, a quick note on Lawpath's legal, tax, and accounting support. Our legal advice plan gives you unlimited one-on-one legal consults with our expert lawyers, much like Damon, for example, helping you with everything from compliance to contracts, trademarks, and much, much more. If you are also looking to get your books in order, our accounting advice plan connects you with qualified accountants for unlimited tax support, including BAS, payroll, bookkeeping, and ASIC. It's Tim's division and Tim's team. Again, questions, please send them my way. I'll address it with them. And right now, you can get a 20% off legal advice plan if you choose a quarterly subscription. And this offer is only for those who are attending the webinars. Let's kick it off with Tim, understanding your tax obligations in FY 2025. Essentially, what we will be addressing here is how to prepare end of financial year reporting, which deductions you might be overlooking, tips on record keeping, and to avoid ATO audits, and what changes apply if you were a sole trader versus a company. Please go ahead and take it away, Tim.
Thank you very much for the kind introduction. Let's get straight into it. We've been mucking around with slides already. Let's start talking. Let's start delivering some value to you. Let's see what we've got on the cards today. First of all, we're in kind of a new era of the ATO. For those of you that think you know everything about how the ATO operates, I would say halt there and be prepared for a bit of an education. The recent budget that you would have all followed with eager ears and eyes and have been probably a little bit disappointed because there wasn't too much meat in it. One of the things that did stick out to me as someone that works in this area is that the bank of the ATO is closed. And I have alluded to that in a couple of webinars before, so forgive me if I'm harping on, but I've got an update for you. That door is slamming shut. So the conversations that I've been having with the ATO in recent weeks have taken on a different tone. For those of you remember the lighter times of ATO compliance, particularly during COVID, there was a lot of discretion given. There was a lot of waiver of penalties, a lot of, interest was on halt, seemingly indefinitely. We knew it was going to change, and sure enough, it has. Now, what has that meant, and what is this budget announcement that has given the ATO a lot more money and a bit more compliance powers mean to you? It means that we're now going to see failure to lodge penalties enforced with vigor and earlier. It used to be there was a lot of discretion at the ATO officer, and smaller businesses often didn't see them until 2 years, 3 years down the track. We're going to start to see them more frequently, and I've certainly seen more coming across my desk. These penalties are not deductible. So unlike all of your other business expenses that can reduce your tax payable, too bad, too sad. You'll have to pay it and get no benefit for it. Likewise, the interest on your late payments. It used to be like interest to the bank or interest on the credit card. It was all deductible. Soon, coming 1 July, that will change. Now, the interest on those late payments is 11% roughly. If you take into account that it's not deductible, the effective rate of interest is more like 15, 16%. So it's becoming more important to stay compliant at all stages of your business, whether you're a startup, whether you're in growth phase, or whether you've been doing this for a while. We've known for a while, super late payments there are not deductible. That will continue. Super's only going to get, say, harder. It's going to get more obligation heavy from an employer's perspective as time goes on. We're not too far from 2026 where you'll have to be paying your superannuation on the same day that you pay your employees, not just once a quarter. And like I've mentioned, we're tightening up rules from the ATO's perspective, and we're seeing more audit activity. You can imagine that with this access to big data that the ATO has, you would be surprised what they know. They have access to immigration records, car insurance, boat insurance for those of you that like to get out on the water. And if they're starting to see things that don't tie in with your profile as you've described it to the ATO, expect to get, if not a knock on the door, then maybe a phone call. What I do always stress for new businesses, I know what it's like when you set up a new business. It's exciting, it's fun. Tax compliance is the last thing you care about. You want to get to work. I get it. Don't leave things a year. Get started as soon as you can. As soon as you take a break from the exciting things, get an accountant on board. Our ethos at Lawpath Tax and Advisory is that we get introduced and we get on boarded with you straight away, so that there's no late nights for you. You're not wondering when's that next thing due, or oh, I got that nagging feeling that I haven't done last year's tax return. Get a professional on board that will handle that for you. Why are we talking about compliance now? In reality, what we're doing for most of our clients is lodging 2024's compliance now. 2024's compliance, way back last June, isn't due until the middle of May. Why are we talking about next year's compliance now? Because a lot of what you can do to improve your tax and financial situation has to be done now, has to be done before the 30th of June. A lot of the really good deductions and strategies available can't just be done with the stroke of a pen. They can't be an entry in your Xero or your MYOB or anything like that. A lot of things require payment now and require minutes and resolutions now while they're contemporaneous. So getting an accountant on board now while there's still time to improve your situation is really, really important. More importantly, what if you've made some mistakes? We all do it. Plenty of people have made errors in their financial records, or perhaps borrowed some money from somewhere they shouldn't in relation to some intermingling of their corporate and personal affairs. No problem. You're still in the financial year. Most issues, if you resolve them within the financial year, are fine. They don't need to be reported. So the longer you wait, really, the fewer your options, as we've discussed. And getting on top of things early means that you can really make meaningful change to your situation, not when it's too far down the track and it's well, that would have been nice. Let's do it now while it is still nice. Right. So now we're talking about, okay, if we've got this business, if you've got your idea, now that we understand that compliance is important and we want to start this business on the right foot, we've got in the back of the mind compliance mindset. Let's now talk about the mindset that's going to generate the most long-term gains, the long-term wealth that a lot of people are looking to when they start up a business. Your structure is incredibly important. Damon can talk about asset protection till the cows come home, but from a tax perspective, the excellent legal protections that a business structure with a holding company above a trading company, uh, it goes hand in hand. This separation of ownership of assets and risk has great tax implications as well. Um, Even before we get to family trust, just the holding and operating company is a really good scalable system for attracting investment monies, pardon me. So it's a very, very common structure. You'll see anyone that you see out there in the announcements that have raised X million from venture capitalists, that is not going into the operating company. You'll see that's always going into a holding company. Does doubling up on your structure mean you have to double up on your compliance? Not necessarily. You can consolidate your tax affairs and still lodge one tax return even from one entity. This is called a dual structure. That E in dual should definitely be an A. So bear with us on that one. That we're not talking about fisticuffs or sword play or anything like that. When we talk about a dual structure, we talk about this idea of the holding and the trading company. We take it one step further with the addition of this family trust at the top level. And the family trust is really where we unlock a lot of tax benefits. This flexibility that we talk about. You put on your hat as the trustee of a family trust, and you get to look around you at your family members and knowing their tax situation, who can take a profit distribution from your business the best way? Is it someone that's already earning $200,000 and paying 47% top marginal rate of tax? Or is it potentially an adult child who's studying and you're paying some of their expenses? There's often better ways to do it. And flexibility of family trusts are incredibly important. There are further asset protection purposes as well. No doubt you would have seen some very famous trusts in the news at the moment if you've been following the affairs of the Murdocks and the Reinhardts of this world. But those asset protection purposes at the top end of town are just as relevant for smaller family trusts. It's not just a good way to hold your business, it's a great way to build your family wealth if you're looking at investing in the stock market. If you can get onto your CommSec or your Westpac broker, I know it's a difficult time if you want to buy shares when the market drops out. Everywhere crashed yesterday with people trying to get in and buy some value or potentially sell out of some risk. When we're talking about share capital, these are all the considerations we look at when you're starting up a business. It's very tempting. It's very common to start up your share capital with mum owning one share at a dollar and dad owning one share at a dollar. That's fine if that's all you want to do. If you are looking to attract outside investment, it's usually better to start with a much higher number of shares. The simple reason being, if you want to sell some interest, some equity in your company, you're in a much better position if you only have to sell 1/10,000th at a time rather than 33 1/3%. None of these things are fatal. If you've set up with two shares at $2, it's absolutely fine. It's just another little bit of work to do what we call a share split and get you to that optimum position with lots of shares on issue. At the time when you're setting up, the cap table is important. Again, a cap table is a spreadsheet. Let's not overcomplicate it. Um, but what it does show is over time, as you raise money, the dilution of your shareholding. So it's important to consider, particularly if you're a business that is looking to raise money at different rounds, so at different points in your business growth, having a cap table from a professional shows you that, look, every time you grow your pie, every time you get more money in, you'll be getting a smaller slice of that pie. And what does that look like for you? And it can include things like employee share option pools and option schemes, things like that. So it's really important to get again across this. It's very, very difficult to reconstruct a cap table. And anyone that's had to do it, any lawyer or accountant, would be cursing under their breath that it wasn't done right the first time. These records are really important to keep. Like I said, reconstructing one is a nightmare. There are things that have to be signed. There are still wet ink signatures required for some elements of capital raising. You'd think in 2025 that's gone. It hasn't. If you think dealing with the ATO is difficult, wait until you try and dealing with ASIC. They are dinosaurs in some respects, and a lot of these documents are really, really important. I would never recommend anyone went into capital raising without a lawyer on board who's done it before. So Damin and his colleagues, this is their bread and butter. Leave it to them to worry about who's dotted the I's and crossed the T's. Don't try and do it yourself. Again, if we're talking about structuring ESIC, not ASIC, ESIC is the early stage innovation company tax offsets. Phenomenal incentive. It's not going to be good for you as the founders, but it's going to be very attractive to the next round of investors coming in. These give fantastic tax offsets available for basically taking a risk as being the next people on board into a company, your angel investors, if you would. There are some limitations depending on the type of investor you are, but not only do you get this upfront offset from getting in and putting your money where your mouth is, you actually get a 10-year exemption on capital gains tax. So if you've taken the punt, you've banked your offset, you've reduced your tax bill there incredibly effectively. Good news, your company investment has gone through the roof and you've sold it 8 years later. Well, fantastic. You won't be paying any CGT on that, provided that your interest was below 30%. So a really, really great one to look at. There are some qualification steps, of course, but talk to a professional. We can help you get it done. Mentioned ESOP very briefly before. Lots of people are familiar with this. They're very common. People have probably heard about them if you hear all of the great success stories of people that have come on board. And there's the most famous scenario. I think it was the guy that painted the mural in the Facebook office ended up with X squillion dollars worth of ESOP. Those cases do happen, and I've been very fortunate to advise on a lot of companies setting up an ESOP, and I've seen some wonderful success stories. They are, of course, a great way to attract staff and to retain staff because often, if you know what it's like starting up a new business, cash is flying out the door everywhere you look. This is one way of getting the right people in and aligning their interests with yours. It's a way of saying, let's go on this risky journey together, but if it works for me, it'll work for you. So often you see 8, 10, sometimes 15% at the higher end of the shares set aside for this purpose. And again, fantastic tax exemptions available, particularly for startups. No one goes out there and starts their business without having thought about a budget, how complicated your budget is. It might be on the back of a beer coaster. It might be a very complicated financial model. What I would say is have one in place to the best of your abilities. Do what you can. Know what your objectives are and what do I want from this business? What's it going to look like? Try and plan for it. Try and plan for what you think is best case, worst case scenarios, and then have a worst case scenario as well. Know when you've got to cut the cord. I think that's a really important thing when you are budgeting. Know when you've committed beyond what you think you can come back from. Particularly, you do have legal obligations in relation to staying solvent. Know when you're approaching that limit. Don't try and look back and work it out. Know when you can pay your debts when they fall due. Of course, understand the market as well. You don't go into this thing without having done your research in terms of what's out there. When we do talk about budgets, you don't just it's not a set and forget process. You should be looking at your budget at least once a financial year. I mean, at bare minimum. If you're not looking at it every quarter, you're probably mad. But certainly this time of year, as we're coming up to financial year, you should have a pretty good idea how your 2025 is going to look. So now's the time to inform what you think your 2026 will look like. Please allow for your taxes. Don't think that money in your bank, if you've had a good year and you've made, let's call it $1 million in profit, fantastic. Don't commit to spend that $1 million because, of course, you'll have roughly $250,000 of tax to pay to the ATO in company tax, and that will fall due sooner than you'd think. So do allow for it. Obviously, your BAS as well. You should have a reasonable idea of what your BAS commitments will be once a quarter, perhaps more often. So use these historical transactions. Use what happened last year to inform next year. But of course, speaking to your professional and making sure you understand where things have changed as well. Look again at your business objectives. They might not have stayed the same. Plenty of startup businesses will pivot, and that's fantastic. You might have a completely different financial model to just 6 months ago, but do make sure that you take another look at it, take a really purposeful look at it. The ATO has just recently published their most recent benchmark data. This data is important for two reasons. It gives you an idea of how profitable and how expensive it is to run certain types of business. And they give you very broad categories, but it's useful. It's also useful to understand a little bit of that insight into the compliance mindset of the ATO, in that they know what your business does, they know a little bit about you, and they know if you're reporting to them a business that is wildly out of expectations with benchmarks, it's probably a good sign you're going to get flagged for a bit of audit activity. So it's good to have it in the back of your mind. Of course, you've got to consider all of your costs, your growth expenses. If you're hiring new people, it's all going to come in. Everything you know about your business should be on the budget. When you're looking to expand, it becomes there's often a few sort of points of inflection in a business growth that you see very commonly. You start to think about maybe one company is not enough for us. Maybe we're doing different things with a sufficient risk profile that we want to ring fence that and we want to separate it out from what we're already doing. Even if you're not splitting into a new company, do we need to do project tracking in our accounting software or something similar? Do we really need more visibility than just a very flat look at a P&L? Do we need to break it down? How are you going to fund this expansion? Debt versus equity. There's a whole industry of people out there offering particular debt products for businesses. And I've loved the way they've adopted the phrase non-dilutive funding, which is a nice way of saying interest-bearing debt. But there are occasions where debt is better for your business than giving away shares. You really got to consider it closely. Don't go it alone without thinking you need marketing and sales. It's a very important part of a growing business. How are you going to fund all of your expensive things that you want to do next year if you're not getting the income in the other side? Of course, you should be looking at grants and tax offsets. The R&D one is particularly good. The EMDG one, less good. It used to be phenomenal. It's kind of dropped off. But you should have a look and see what's out there. And different states have different state tax incentives and state grants available also. Think about your finance team. There is a later slide about that. Is your finance team just currently you? Probably best to offload that to someone else. Probably best to focus on running your business and get someone else in. And seek advice on everything. I'd say it's a great time, as we mentioned, in the run up to June, to talk to someone about your expansion considerations. Yeah, this finance function can be as complicated as you going it alone. If you're really good at getting into your accounting software and reconciling transactions, and that's all it takes, and then you've got a professional that does your lodgements and is there to advise you, that might be as complicated as it needs to be. If you're up until 2 in the morning every night, if you're losing your life to losing your weekends to scrabbling around in software and you're not comfortable with what you're doing, you need to expand your finance team. You need to make sure that you've got someone in there doing at least a month-end close, which is where you basically look at your full balance sheet and you get it up to date. And you do that often by the middle of the next month. So you know that all of your records are accurate. You don't leave it until the last minute or look into it next year and then realize, oh, it was a disaster all year. At least if you're making mistakes and if you're doing a good month-end close, you'll catch it there. So having that access to really up-to-date financial information is the only way you're going to be able to track your business success as you go. It's too late to look at it just once a year. Tax considerations. As you get bigger, unfortunately, your exposure to tax grows too. This is going to be a very rude shock to anyone who has been a lovely employer and has provided non-cash benefits to their employees without having heard the dreaded letters FBT, fringe benefits tax. It is the number one thing you see forgotten about. If two earnest people go out and set up a business and hire a third and want to provide non-cash benefits, health insurance, motor vehicles without thinking too much about it, anything you can imagine, expensive meals, expensive holidays often. The ATO does not like fringe benefits. The reason being they're much harder to track. The ATO can see how much you're paying in terms of a cash transfer. So they like payroll, they like salaries. They don't like you giving a thing. A thing is harder for them to track. So what they say is that if you are giving employees things, we'll have a system of taxation that taxes these things effectively at 47%, regardless of the person's salary. So fringe benefits tax, there are concessions and exemptions available. depending on your type of business, but it is complicated. It's fiddly. Do get involved with someone that knows what they're talking about when you're thinking about these benefits. Payroll tax, these are state taxes, so not paid to the ATO, paid to Revenue New South Wales or the equivalent in Victoria and Queensland, all over the place. Everyone charges payroll tax, to my knowledge. There have been moves to make it similar, more similar across the country. So if you're someone that employs people in different states, hopefully you only need to know roughly one way of calculating it, but the rates of payroll tax are different for each state. So again, can get complicated. Even with your ATO lodgements, you might be reporting a lot more frequently than you used to. As you start to pay more salaries, you go from being a quarterly withholder and reporter to monthly pretty quickly. Likewise, if you've been a very small trader and you've been eligible to do annual GST reporting on your BAS, you'll very quickly hit that threshold for quarterly. So your frequencies can increase. And if you're profitable, you can start entering what's lovingly called the PAYG installment system, where you might have to start prepaying some of next year's business tax. So that is a difficult and very unwelcome letter that you get from the ATO if you start being profitable. Just to try and remember in the back of your head, paying tax is a good problem to have. It means that you're profitable. Capital gains tax, look at as you're expanding and doing different things and restructuring, we have to be careful we don't trigger capital gains tax. There are exemptions and rollovers that we can apply for small businesses. It is complicated. It's a reasonably complicated bit of legislation. It's worth getting someone to have a look at it and making sure that you're doing the best you can to avoid any tax. When we talk about director loans, it's a common area of ATO compliance. It's been a very famous case in front of the courts recently. It's now going to appeal. And the ATO has said, in the meantime of the appeal, we're going to ignore the last court's warning and we're going to keep doing it the way that we want to do it. This thing called, there's 100A, there's Div 7A and Part 100A. They're different ways of attacking the same problem of, are you taking money out of your business that hasn't been taxed yet? And of course, the ATO frowns on that very carefully. It will start to deem you as having received dividends, or there'll be particular loan agreements that have to be put in place and have to be adhered to. I would never advise anyone tries to go it alone. It's horrendously complicated. Please do talk to a tax professional if you've got loans between your company and yourself as a director and shareholder. And now I'll hand you back. I don't know. Let's go straight to Damon. He's probably raring to go.
Thank you very much. Thanks for that. Yes, I've had a lot of clients fairly upset by the fact that the ATO is now a lot more stricter. And it used to be a case where people would negotiate installment plans and they would try to get the penalty interests waived, and that's no longer the day. The ATO is now cracking down, and so if you have any ATO issues, you should contact your accountant as soon as possible. Now, let's look at some of the updates in law. But before we do so, we're just going to go into some of the contract items. It's amazing that when we look at contracts, some of the essential elements of a contract are actually missing. So, for instance, where's the termination clause? Who has the right to terminate? These are really, really important things. Sometimes people will have contracts that will just say it's a 1-year contract fixed over the period of time. And if you were to terminate the contract early, then the client has to pay the entire balance for the entire year. Now, the ACCC has been prosecuting larger companies. That's basically called a fixed term contract. And a fixed term contract could potentially be an unfair contract term under the Australian consumer law. So let's break this down a little bit. Number one, if you have a contract, is it for a period of time? If it is for a period of time, how long is it for? And how do people terminate? So you as the service provider, do you have certain rights and are you allowed to terminate? And does the customer have certain rights to terminate? Normally we have one, which is if a party is in material breach of the contract, then the other party will give 14 days notice for them to remedy that defect. And if that defect or breach is not remedied, then the other party can terminate the contract. The other one might be that either party can terminate if one of the parties have gone insolvent, or if one of the parties has evidenced their intention to no longer be bound by the contract or to breach a non-solicitation clause, for instance, in the contract. Or it might just be that either party can terminate by way of notice, 30 days notice, 60 days notice, 90 days notice. But these are all very, very important contract terms. So if you do have a contract, you want to look at your termination clause and make sure you generally would have those kind of provisions in your contract, whether it's termination for convenience, termination for breach, or termination by notice. But again, if you have a contract that is simply a fixed term and there is no way out at all, then the question is well, what do they have to pay if there is a breach by you, and what do they have to pay if there's a breach by them? And you've got to make sure you don't fall foul to the unfair contract terms, because if it's just simply a fixed contract and no one can get out of it, and you expect the customer to pay you for the entire fixed term, well, the ACCC and under Australian consumer law have found that that could potentially be an unfair contract term, and possibly the payment of the entire balance of the contract is deemed a penalty. And a penalty clause in Australia is not legally enforceable and will get struck out completely. And the reason for that is that the law in Australia says that someone can only benefit from a contract term if it actually is a legitimate business interest, which means that normally it has to be a pre-estimated loss as a result. So for instance, if you're on a subscription plan for 12 months, you have to pay $1,000 a month. And then the other side, the person providing the services, just isn't providing the services that you were told, and you quit after 6 months, then they send you a bill for the entire 6 months remaining in the contract. You could argue that that's a penalty and that that fixed term contract is unlawful or not legally binding because it doesn't protect the legitimate business interests of that person, because they no longer have to service you. So why are you having to pay the full price? Now, this kind of area of law has been going on for a long, long time, but I can remember in around 2008, fitness first contracts were challenged because people were signing up to a 1 year membership. And in those circumstances, people were trying to get out of the 1 year membership and claiming that the contract was not legally binding and unenforceable. But in that case, they found that Fitness First had a legitimate business expectation. They needed to know how many members were locked into a 1 year contract so that they knew how many people to hire as personal trainers, so that they knew how many new offices to open, whether to build another gym around the corner, and so on. And the court found that it was a legitimate business expectation to know how many members you were going to have into the future so that you knew what kind of growth strategy you were going to implement. So it's not always a fixed term contract with no termination clauses going to be not legally binding, but it is something that you really do need to look at. The same thing goes for an automatic renewal clause. If you have a contract that just automatically renews at the end of the term, you want to make sure that there's clear notice given to the customer that it is going to automatically renew. And the best way to do that is put in your calendar, have some kind of automation reminding the client that if they want out at the end of the fixed term, then they should send a notice to terminate. Otherwise, it's just going to automatically renew. And the reason for that is because automatic renewal clauses have also been challenged by the ACCC for the big guys anyway, that if reasonable notice isn't given, then it's not going to be necessarily legally binding. Also, we look at a lot of contracts, and sometimes it says, I can terminate whenever I want to, you can't. That also is an unfair contract term. And in the Australian consumer law, they actually give examples of unbalanced contract terms. So if you have a termination clause that says you can terminate here, but they can't, it might be unfair. It might be not legally binding. And so what does that mean? That if you do have an unfair contract term, what does it mean for you? If you try to enforce that clause and continue to persist that that clause is binding, and they go and get a court order and a declaration that that clause is not legally binding, then they can issue penalties on you for trying to enforce an unlawful clause. So that's just some of the things that you want to look at in your contracts. Now, is your business protected generally? You want to make sure that you have contract terms and that have possibly a dispute resolution or maybe an arbitration clause. Now, a dispute resolution clause is normally dealt with when you have a bigger clause or a bigger contract. So if you're servicing someone for $100,000 or more and someone's not paying, you don't want to go through the expense of going to court and having to fight it out in court because legal fees are very expensive. So as a first measure, you want to try to sit down with them, try to negotiate a settlement. And if you can't, then you want to go to arbitration or go to mediation, sit down in front of a mediator for 8 hours, trying to net out a deal. And if you can't, then you go to court. Now, it might not be reasonable to have a dispute resolution clause if you're just selling a good that's worth $30, because then the cost of running a mediation is more than the cost of that product itself. The other thing to look at is if you're dealing with business internationally, you might want an arbitration clause. There's something called the New York Convention. The short form is the New York Convention. The long form is the New York Convention for the Foreign Recognition and Enforcement of Arbitration Awards, 1958. And basically what this New York Convention says is that anyone to a commercial agreement can agree to contract out of court. So you can mutually agree that if there's a dispute, you're not going to go to court, but instead you're going to go to arbitration. And arbitration is basically going to an individual person, normally one arbitrator, who makes a final binding decision. The process is very similar to court, where you file your claim, they file the defense, you file their evidence, they file their evidence, and then you go and have a hearing in front of one arbitrator. But the difference is that if you get an arbitration decision, you can then have that enforced in 151 countries around the world. So to give you an example, you're doing business with someone in New York, you don't have an arbitration clause, you provide the services, they don't pay. Your contract says that Sydney is the jurisdiction for a dispute and New South Wales is the applicable law. In that case, you then go and sue in the Sydney courts, and then you get a judgment. And that's great. You get a judgment. They might not have even defended against it, but you now have to enforce that against the assets in New York. Well, we don't have jurisdiction over assets in New York, and now you've just got a judgment from Australia that's not necessarily enforceable in the United States because we don't have recognition of judgments between the two countries. Now, so you now have a judgment that you can't do anything with. Whereas if you had an arbitration decision that said, for instance, the clause says that arbitration is a way to resolve the disputes under Australian law in New South Wales, and Sydney is the place for the arbitration, and then you get an arbitration decision, you can then walk into the court of New York and say, here's my arbitration decision from Australia, and they can then stamp it as if it was a New York decision, and then you can enforce it against the assets. So those are some things that you want to be looking at. Another thing is when you're looking at the actual contracts that you want to be making sure that you're complying with your warranty provisions and your consumer guarantees. So under Australian consumer law, if you're selling a good, it has to be merchantable quality, it has to match the description maybe on your website. If you've sent any samples, it has to be matching the sample. It has to be fit for purpose if any disclosed purpose was specified, and of merchantable quality. If you're selling goods or services, it has to be delivered within a reasonable period of time. It has to be performed with due care, skill, and diligence, and also fit for purpose if it's being disclosed. So these are some of the things that are mandatory laws. And if you have a contract that tries to exclude them completely, then those clauses aren't going to be legally enforceable. So make sure that your products are complying with Australian consumer law, but also make sure that when you're buying from somebody that make sure that they are giving you the warranties that you're entitled to. The other thing to look at is when we have situations where there is a breach of a contract or where one of your faulty goods are defective, what is your warranty procedures? What is your policies? And how do you go about that in resolving that issue? And then the other thing to look at is your intellectual property. A lot of people go and they register a company and they get really excited because they get the name of that company that they really, really wanted. But what they don't realize is that that doesn't mean really very much at all. It doesn't protect your brand. It doesn't protect your intellectual property. If you're going to create a company, you want to first do a Google search. You want to see, is there anyone else operating with that same name? You want to do an ASIC search. So you can go to ASIC Connect and you can type in the main name that you want to use and see if there's any other companies with that name. You then want to do an ABN lookup, see if there's any trading names or business names registered. And then you want to go to IP Australia and have a look at see whether anyone has a trademark. And the reason for this is that you could go and incorporate a company called Lawpath Services, for instance, and you get really excited because you were able to get that registered. And you're able to register it because Lawpath is called Lawpath Operations. So just because we have Lawpath Operations doesn't stop you from registering a company called Lawpath Services. However, if you looked at IP Australia, you would see that Lawpath is a registered trademark. And that means that we have the exclusive right to the word Lawpath. And by you incorporating a company you're trying to trade as Lawpath Services, we can send a cease and desist letter and sue you for trademark infringement and possibly copyright infringement as well. So if you're going to incorporate a company, you need to make sure that your brand is unique and distinctive to others so that you don't spend a lot of money on marketing and branding your business only to find out later that you're infringing upon someone else's copyright. And conversely, if you do come up with something unique and distinctive, you probably want to register it with getting a trademark so that it can stop other people from using that brand. Now, going back to the agreement, a lot of people will say, well, my obligations to you is I'm going to build your website for you. And I will do this, this, and this. But what people forget about is the obligations on the customer and what they owe to you. It's not uncommon where we act for software developers and the software doesn't get developed on time, it goes over budget, and so on. And the reason a lot of times is because the contract doesn't put any obligations on the actual customer. So the software developer might say, well, here's your architectural drawings for your software, please get back to me. And it takes them 3 weeks to make any decisions. Or it might be, we need to make this change, please give us this approval, and no one responds. And that's where it all gets dragged out, and that's where the budget and the time escalates and escalates and escalates. So if you're doing services, you want to make sure that there's an obligation on the customer to give you the instructions and the documents and the approvals necessary, and within a reasonable period of time or within 7 days, so you can advance that work. So make sure there's obligations both ways, not just from the service provider by giving the services. Same thing with goods. You want to have clauses both ways. So if you're delivering goods and you are given their address and you go and deliver the goods and the address is incorrect or no one's available to collect the goods, then you want to have a clause saying, well, it was your obligation to give us the address. It was your obligation to be available at the time to collect the goods. Because you weren't, we're going to pay you or we're going to charge you a redelivery fee. And those are kind of clauses that you want to think about going both ways. So those are some of the things to look at when you're looking at contracts. Now, there's been a lot of developments in employment law. Some of the things going back a little bit. So if we look back in 2023, there was flexible work arrangements. It used to be that flexible working arrangements were only specific to categories of people, like carers, mothers, things like that, or people maybe with an illness, and they could ask for flexible work arrangements. So for instance, can I come in at 10, leave at 3, and then go back to work from 8 till 10 so that I can collect and drop off my kids from school. And back then, if they were the care, then you could look at that and you had an obligation to respond and more likely than not to approve. But now it's anybody has a right to ask for flexible work arrangements, and you must respond within 21 days with your answer as to whether you're going to approve it. And you're only allowed to not approve it if there's genuine reasons why it's not going to be working for your business. So you have to have a legitimate business expectation or a reason to refuse flexible work arrangements. And this is quite common from working from home. And on the point of working from home is if you have employees and you put in the contract working remote, then in those circumstances, you really can't change their employment condition because you hired them to work remote. And if you were later to implement a policy that says you have to work 2 days a week in the office, well, the problem with that is that you can't change it because it's written down in an employment contract. So instead, you've got to put work in the employment contract. You want to be putting working from the location specified by the employer, and then you want to have a work from home policy that says at the moment it's 100% remote. And then later on, you can change the policy, but you can't change the employment contract itself. So those are just some things to point out in terms of flexible work arrangements and work from home. There's also a prohibition now on fixed term contracts. So it used to be that people would put an employee on a 1 year contract and then renew it for another year and keep on doing it for years and years and years. And because they're on a 1 year fixed term contract, there's no legitimate expectation to be permanently employed. And in those circumstances, they don't have grounds to bring an unfair dismissal. However, now there's a prohibition on fixed term contracts that exceed 2 years. So if you hire someone on a 1 year contract and you renew it for another year, and then you go to renew it for one more, they now become permanent. And there's only certain exemptions to get around this. And this is if it's project based normally, or if it's for a specific purpose. Now these prohibition on fixed term contracts only applies to those in the under the high income threshold. Now, the whole relationship test is quite interesting. We've had a lot of high court decisions over the years. On the left-hand side, you can see those high court decisions. Essentially, it used to be when you hired a contractor, you give them a contractor's agreement and you say, send me your invoice and I'll pay you. And then you would assume that they're a contractor. But then the courts went and said, well, no, not necessarily. We're going to look at the contract predominantly, and we're going to give weight to that because the contract says they're a contractor and they're invoicing as if they're a contractor and they have their own ABN as if they're their own contractor. But we've got to look into different factors. Are they using your computers? Are they using their own computers? Are they wearing your uniform? Are they wearing their own uniform? Do they get to choose their hours? Do they have their own insurance? Things like that. And there's a bunch of different factors to look at. And the high court decisions came down in 2022, and it said we still predominantly look at the employment or at the contractor's agreement to determine whether they're a contractor or an employee. And only certain circumstances will we go beyond what's in the contract to look at those factors. Well, the government didn't like that. And so the government has now effectively changed the law that was made by the High Court and have said, no, we're no longer looking at the contract. We go straight to the considerations and we look at what the real relationship is. And this means that whenever you hire a contractor, even if they have a contractor's agreement, they could be deemed an employee. And so it's really, really important that if you're hiring a contractor simply to possibly circumvent the employment laws and the modern awards, then you have to think hard and fast whether that's going to be appropriate or not. Because if it is found that a contractor is actually an employee, you could be ordered to pay all the past entitlements that they haven't received, like public holiday pay, long service leave, annual leave, sick leave, and all the rest. So just be very wary about hiring contractors. The right to disconnect, you would have seen this on the news. It's basically saying that you shouldn't be communicating with your employees or expecting them to respond after hours. Now, there are exceptions for urgent matters, but generally speaking, employees have the right to disconnect and not have to stay on the pulse and check their phone and their emails all the time. And same job, same pay. This is getting in relation to normally larger enterprise, but basically it says that if there are employees under a modern award, for instance, or under an enterprise agreement, and they get a certain pay, and the employer doesn't want to actually hire an employee under those conditions, so they go to a labor hire agency and they say, here, can you send me over a contractor and we're going to pay them less and give them less rights. Then under this same job, same pay, that's unlawful. And any contractor who is subcontracting through a labor hire arrangement has to receive the same entitlements that an employee under an enterprise agreement or modern award would receive. Unfair contract terms as well. Sometimes under contract, there's some very onerous clauses. It could even be a non-solicitation or a restraint of trade clause. Now, before you breached it or intend to breach it, you can first go to the Fair Work Commission to make a decision on whether that clause is unfair and legally binding. So for instance, if you wanted to start a competitive business, but you're really concerned about the restraint of trade clause, you could go to the Fair Work Commission and say, I want to go and start this competitive business. My employer won't let me. I want a decision that this clause isn't enforceable before I actually go and do it. So that's it for now. What I'll do is I'll pass it over to Joel. He can talk about the legal plans, and then we might have some questions. If you do have questions and you've jumped in, and we're sorry about the difficulty with the link. If you have any questions, doesn't matter what you want to ask, but whether it touches this webinar or anything, feel free to start dropping them into the Q&A. We've got an accountant here, got a lawyer here. We're talking about anything tax and law. So feel free to dump it in, and I'll pass it over to Joel.
Thank you so much, Damon. I myself do not own a business. I've never really had the idea to own my own business, but I feel like the more I'm participating in these webinars, the more comfortable I feel about the whole idea. So who knows? We'll see what happens in the future. Ladies and gentlemen, do you recall that tender age of around maybe 16, 17, or 18 when you decided to leave the nest and move out for the first time on your own? And you were very naive, and then you were thrust into the world, and then you realize, crap, there's a ton of stuff I don't know. How do I do my taxes properly? What kind of fabric softener do I use? I've been eating so much junk food. I need to actually start cooking and eating more healthier meals. Who would you usually turn to at that point? You call mum and dad, right? Mum and dad are the be all and end all. You know, you look up to them as the shining beacon of knowledge and understanding. Essentially, that's what Lawpath is for your business. Now, you're probably wondering, why am I using a parental analogy? Because the good thing about having parents is they will always pick up the phone when their child calls. Now, if you were to click a button and dial, you're likely going to get one of the two instantly. Now, if you were to consider any other legal or accounting firm and you call them, we'll pencil you in 2 or 3 days time, maybe next week we can book you in. With Lawpath, it's not like that. If you call, you will likely get a same day consultation, or it will be a next day consultation. That's one of the great value propositions that we like to provide our clientele. Now, with the legal, accounting, and tax, it's very simple. It's a single payment of, as you can see, the price is here, and you get complete access for 12 months. There is no other fees or anything else involved. Now, in regards to certain legal topics or accounting topics that go outside the parameters of the legal or accounting advice plan, naturally there might be an extra fee that we would charge for something a bit more complex. But for the most part, if it's just general assistance in having your documents reviewed, assistance on determining what documents you might need, general business advice for legal, things of that nature, the kind of things that Damon discussed today. It's all that kind of knowledge you're getting on this plan. If you don't see any benefit to having legal advice, but you are happy to be very autonomous and you're a go-getter and you're a busybody and you like to do things on your own, we have the Essentials plan there, which will give you access to all of our documents, pre-templated. We update it when legislation's changed around Australia, and that's always available for you. So nice state-of-the-art legal documents. In regards to the accounting and tax, Same premise with the accounting advice plan. It's unlimited consultations with the senior, and as opposed to the legal side, it's the accounting side. We will teach you how to run your payroll, your bookkeeping, your invoicing. Do you wish to invest money in certain areas of your business? Do you wish to save money for a future purchase? Are you taking on employees and things for the first time? It's a lot of information, and you want to know what you can do to, spend your money wisely, but also to reduce the amount of taxes that you're paying. So we can assist you with that on the accounting plan as well as the tax plan as well. Now, with the legal advice plan, and the accounting plan, that is very much you working and doing a lot of DIY, but mainly working and having that parental figure overshadowing and making sure that you're making all the right moves and steps. Regarding the tax plan, however, the tax compliance plan, that's us doing everything for you. So if you just want to, it's been a long day, you just want to sit back and relax and let us do everything for you, it's your BAS statements, your tax returns, your end of financial year statements, all that good stuff that would usually have you pulling your hair out. There is a great cohesion between the accounting and tax plan. We do find a lot of our clientele will go and use the both as opposed to just individual ones, because you're having an accountant assist you with setting all that up, and then you're moving over to the taxes for us to, shave off any splinters or anything else that you might have overlooked. Now, if you are interested in our plans, we do have the individual payments. However, if you would like to combine two plans together, or three or four, however you like, we do have our bundling system, which is a 40% off discount on every single plan that you do combine together. So as you can see here, the legal, accounting, and tax plan, this is our be all and end all plan. This is the main pillars, the superstructure of any new business. We like to think of this as a first year business plan for any business coming in. This will basically cover you for everything, all the education's there, all the compliance is there, and it's just a great way to set you up for future success. The wonderful thing about Lawpath is I have mentioned a lot that, I've mentioned a lot about new businesses, but Lawpath, as you can tell by Tim and Damon's expertise, and I do highly recommend you look them up on LinkedIn to get a complete grasp of their experience. We scale up with businesses. So if you're a new business, if you've been around for 10 or 15 years, or if you're at the stage when you're a couple of years away from selling, no matter what stage you're in, essentially, we will be there to guide you. We have all the expertise. We're not just new businesses, and that's all we focus on. That is a high demographic of ours, and we do take pride in assisting new businesses get set up, but we're here for any step of your business. So I will send a email out to everyone at the end of this, and it will have a coupon code here for a 20% off quarterly for the legal advice. So if you just give me a moment, I think I have the calculations here. So the legal advice is $1,668 per year. That's the annual cost. And if you were to use our usual quarterly cost, it's about $510 per quarter. So it's a bit more expensive. It comes to about 2,100, but it's a bit more cost effective for those. But with the 20% off quarterly discount, it does come to 429 per quarter. So 4 quarters in a year, 4 payments, and you have the complete legal compliance. Now, 30% off on your tax plan. That's wonderful. I didn't realize we had this, but that's also really, really good. So the tax plan is usually retailed about $2,500 annually. And if you were to do that on the quarterly basis, it's about $900. So with the 30% off, I do believe that comes down to about $630. So $630 per quarter. And also keep in mind, all of our plans are 100% tax deductible as well. And naturally, if you're using one of our accountants or our tax agents, they can really double down on that to make sure you are getting everything back.